Once again, my name is Aaron Plowman, attorney here with Matthiesen, Wickert, and Lehrer, and we're going to discuss a little bit of product liability this morning. And I know it's a hot topic for a lot of subrogation adjusters in kind of how you recognize that there is a product liability loss, how you pursue that, and hopefully I will give you some helpful tips and tricks to kind of guide your way through what really has become and will be a major part of subrogation recovery here in the future. I'd first like to kind of talk about the basis for product liability. Really, there's kind of the two restatements of torts, and you hear these things thrown around a little bit, and I'll show you some language from the restatements. But the restatements basically are a panel of attorneys, judges, law professors that look at the law and kind of try to make a general law for everybody to adopt and follow. It has its it has its proponents, and people not necessarily don't like it either. So there's two sides of the coin, but a lot of states look to the restatements, and a lot of legislatures look to the restatements to try to take the basis of their product liability laws. And so you'll see states adopting in whole the Restatement Second of Torts, the Restatement Third of Torts, or they'll also kind of mix and match, and they'll do that through their own product liability acts. So you really have to be aware of which states you're in, who you are allowed to to pursue, what the law states, as far as your burden of proof, what the law states as far as whether you can pursue a supplier or a component manufacturer, and I'll explain a little bit of that later. But just kind of going through the Restatement Second of Torts, this is Section 402A, and this is the language that you kind of have to follow along with that, because a lot of states early on have adopted this. A lot of times it's called the Consumer Expectations Test, and that comes through Part B there. It is expected to, and does reach the consumer without substantial change in the condition in which it is sold, and, any product that is in a defective condition, unreasonably dangerous to the user consumer. And it's a lot of times it's used as, what did the consumer expect? If, throughout this webinar, I think I'll probably go back to the tried and true water supply line case. I think many of you have probably dealt with these in the past. And, the consumer expects that he has installed a supply line that will not break, will not fail, will not spray water all over his bathroom or home. And you can kind of compare that with the Restatement Third of Torts. And the Restatement Third, each time they do these restatements, they try to take some of the the bad parts of the previous restatements, some problem areas, and they try to fix them. And sometimes that creates new consequences and new issues. But the Section 2 of the Restatement Third, it kind of wraps everything up into one section. You have A, B, and C. A is your manufacturing defect, B is your design defect, and Part C is your inadequate instructions or warnings. But the big change in the Restatement Third really comes in with Part B, and that can a lot of times be a game changer as far as product liability is concerned. And that's because you need to prove that in order to prove that a product is defective in design, you're going to have to prove that the foreseeable risk of harm posed by the product could have been reduced or avoided by the adoption of a reasonable alternative design. And so not only are you going to have an engineer give you an opinion regarding the fact that, that there is a design defect. He's going to have to tell and why, but he's going to have to tell you, well, instead, this seller or manufacturer could have done this, and it has to be a reasonable alternative design. It it has to follow along with manufacturing principles, and sometimes that's easy, such as our case of our water supply line. We know that in the past they have designed the supply lines differently, and I'm going to explain that later on, kind of what they used to have and what they've moved to. And so that there is a reasonable alternative design out in, that was in the marketplace. For other larger machines, maybe custom machines, when you're talking about guarding for presses, brake presses, or guarding for other machines, that can be a little bit trickier, because you're going to have an engineer that is comfortable not only with inspecting the machine and knowing how it operates, but you may have to have an expert who has designed guards, has designed guarding, knows where these guards should be placed, and can give you an opinion on why it is deficient. And so oftentimes that's going to lead to more costs for the plaintiff or the insurance company, the subrogation insurance company in this case. And so you really have to be aware that, in states that have moved to the Restatement Third of Torts, and a lot of times these days states are moving. Just as a quick example, tort reform comes up and gets thrown around a lot, and this is one of the cases that it can really hurt, because if a state moves to the Restatement Third of Torts, all of a sudden, you're essentially changing the game as far as what you need to prove. Wisconsin moved to it in 2011. I know other states are looking towards, moving in that direction, and so you kind of have to be aware of what your state is, is saying as far as the legislation goes. What do you need to prove? Sometimes states mix up the two. They throw a little bit from one and a little bit from the other. They kind of keep, as far as strict liability law goes, they might say, the Restatement Third, but as far as just ordinary negligence, they may follow the Restatement Second. So just be aware of the state that you're in, and what the requirements are for that state. Some other legal issues just to kind of be aware of. When I talk about strict liability essentially means that if you're able to prove that that there was a design defect, the manufacturer is the only person liable for that that defect. However, some states do apply comparative law, and they apply they look at the negligence of the plaintiff. Did they know that this supply line was rusty, corroded, and they let it go and they used it anyway? Did the worker know that the guard was off of this machine, and he knew that the machine should have had a guard in place, but for the time value of keeping the guard on and whatever, that he removed it, and therefore you might have his negligence being applied or being looked at, and that can really affect your your claim. The economic loss doctrine. The economic loss doctrine essentially states that when there is a damage to the product only, let's say you have a fire loss in a vehicle, a lot of times the economic loss doctrine will not allow you to subrogate for the cost of the vehicle. If you have other damages, if there are contents damages, or let's say the fire started in a garage and the garage and house burned down, those are ancillary damages that would apply. So just kind of be careful that you don't put a lot of money into a case and find out that, well, you're only able to recover, the only loss is the vehicle itself, and that is precluded from recovery. There are ways around that, as always. Some states have an accident clause where if it's a sudden accident, all of a sudden the brakes, go out and cause a fire or whatnot. That can kind of be used to get around that. We're also starting to try to use consumer protection laws to try to get around that, to kind of use consumer protection laws as far as, statements made by the manufacturer to try to avoid it and kind of go more of along the warranty route. And then finally, just watch out for the statute of limitations trap. A lot of companies like to delay, cases by requesting more documents, by asking more questions. And in essence, all they're doing is delaying, your filing of a lawsuit to try to recover your lien. And so a lot of times happens is that you will sue one entity that you believe to be the manufacturer, and it turns out that they're the distributor of the part, or they're the seller of this, and that there really is another manufacturer that is, that is liable. And then all of a sudden, you're running up against the statute of limitations, and you need to bring this party in, and it's already, the statute of limitations has already run. At that point, there are a couple of options in various states that, but for the most part, if you can leave yourself enough time and avoid that trap, you'll be better off in the long run, because you'll have plenty of time. If all of a sudden a component part manufacturer pops up, you'll be able to include them in the suit. So how do you recognize, a product liability, loss, and how do you recognize that there's subrogation potential? And a lot of times that comes with training and experience, but most times, the cause of the loss is evident. The supply line broke. You have water, flowing everywhere. The insured saw that it was flowing from, the toilet supply line. The insured saw that it was flowing from the washing machine. But, sometimes with regards to fires or, other catastrophic losses, a lot of times you're going to have to put on your plaintiff's hat and really dive into the investigation and find your evidence to prove your case. And that means, getting experts on board, getting investigators on board. But the key is, a lot of times, is that, you're going to have to think almost like a plaintiff in, how do I pursue this case, and what do I need to prove in order to pursue it? And as before, that means understanding the law and understanding what type of evidence you need. And in the beginning stages, all evidence is important. So we'll talk a little bit more about that here as we go. Your investigation goals is to, a lot of times, always preserve the evidence. That's what you need to prove your case. And so you need to preserve that evidence. You need to put people on notice of the loss. You need to identify defendants. Is there a manufacturer? Is there a supplier? Is there a component part manufacturer? And so you really need to identify, who can be your target, but you also need to identify witnesses, especially in the matter of fires or other, losses where, the cause in origin may not be evident. Well, what happened? What did you see? That also allows you to kind of do your homework as far as your initial steps go. Are there coverage issues? Was this a case of arson? If your cause in origin investigator is able to put that down right away, then you can kind of mitigate your costs up front. But are there any exclusions to the policy? I mean, are you not going to pay out on this claim for some reason because the insurance policy excluded it? So at that point, you can kind of work hand in hand, with any sort of a liability background to kind of take a look and say, well, all right, if coverage is going to be excluded, then there's no reason to go forward and spend the money on investigation. But it also can help you if there is an investigation and there is potential to determine the damages and find out, keep things cost effective as far as investigation versus, recovery. And so if you have a high damage case, it may be worthwhile to spend some more money up front to really pursue your case instead of, kind of letting something go and then learning that, well, I really should have, kept this piece of evidence. I really should have gotten this person involved sooner. So, as with most investigations, who, what, when, where, why, how, always the questions you should be asking yourself and always the questions that you're trying to find the answers to. The who, identify all potential target defendants. So that's not only just the manufacturer, but it could be a supplier. Who did you buy the part from? Who did you buy the washing machine from? Is it Home Depot, Lowe's, somewhere else? Has maintenance or other work been recently performed? Is there a service provider that recently performed, work on this part? Is there an installer that it recently installed the part? All of these parties should be placed on notice so that if they want, they can come and take a look at the evidence, while it is still, in the field, if possible. If it's just a supply line per se, invite them to any sort of testing or inspection that you want to do after the fact. Is there a previous owner of the equipment? Did that previous owner modify anything? Did he modify one of the guards on the equipment? Was it modified at all from the original condition? And then you really need to look at the companies in the chain of distribution, not only the seller, but where did they get the part from? And a lot of times, and I'll talk about this a little bit more in depth, you have a lengthy chain of distribution when you have parts coming from overseas. So you'll have the foreign manufacturer and a foreign supplier, and most times also a U.S. supplier. And there's many people in the chain before it even gets to be installed or it gets to the insured. So what part of the investigation? All this investigation, all you're trying to do is look at and investigate the facts and the details. You want to learn as much as you can, not only about the part or what failed, but the machine itself, how it is used, how it was used at the time of the loss. And all of this is a valuable commodity because this is your one and only chance in order to gain enough evidence to put together your case. And, as a subrogation insurance company, you're going to need to prove that this part failed and that it caused the loss. So you need to gather as much information as possible, as soon as possible, before you even start trying to make a demand or anything else on the legal side of things. But it's your chance to interview the employee potentially before he or she is represented. It is an opportunity to uncover other third parties. Oh, there was an installer of this. Great, let's put them on notice. the gas company was doing work, outside of the home, 2 days before the explosion, well, we need to put them on notice. So it kind of really gives you a chance to get your hands around the entire scope of the issue. And as I said, you need to do this as soon as possible after the loss, not only because a lot of times the insured wants, whatever happened to be repaired, to be cleaned up, but also, witnesses, their memories fade over time, and it's your chance to kind of catch them while everything is fresh in their mind. And a lot of times, the more time that you let go by, it allows evidence to deteriorate, especially, up here in the Midwest, and I know the East Coast has been hit fairly hard by, the cold weather and the winter storms. If you have, let's say, a fire loss that destroys an entire building, well, that building is now sitting out in the elements. Oftentimes it's not feasible to tarp the entire structure. So, not only is your evidence getting, snowed on, the sun is heating it up, melting the snow, which is refreezing, overnight, and a lot of times this can either, hamper the investigation or may even, cause enough damage to where you cannot determine the cause of the loss. You can't determine that a gas fitting failed, and you're not able to save that gas fitting because enough damage has gone over time. So you want to try to be diligent and keeping people up to date and getting these inspections scheduled as soon as possible. On larger claims, that's tough because you have a lot of defendants who are all either scrambling to get their insurance companies involved or getting attorneys involved, and they have all of their own experts. But you really want to try to push it and be diligent in getting these inspections scheduled as soon as possible. If there is a loss site, if there is a lot of damage via fire or other loss, you'd like to inspect the loss site with all potential defendants if possible. And then your expert should be able to retain that evidence for future study. He needs to go through and document his, what he took, where he took it, so it can be, inspected in a laboratory under, more ideal conditions than a lot of times if you're out in, the dust, the dirt, the snow, rain of the loss site. When shipping evidence, always try to take care. I'll keep discussing this in a little bit more in other slides, but you always want to, if you're shipping the evidence anywhere, you want to take care that the evidence, when it's sent, it's packaged so that it is received in the same condition as which it's sent. Because anytime you have if something were to happen to that piece of evidence, worst case it gets lost, and then your case can be thrown out. Otherwise, if it's damaged and your expert in the future can't tell what was the cause of the original loss versus what was the damage in shipping, you may be your case may be harmed by that as well. And as I've kind of spoken the why, it's might be your only chance at the evidence. The repair company is going to come in, they're going to clean up the place, they're going to throw out essentially everything else that is wrecked or ruined. You may miss that piece of pipe that has a pinhole in it. You may miss that that supply line that where all of a sudden the coupling nut has broken. So identify, retain your evidence. It gives you an early opportunity to kind of explain the subrogation process to the insured. A lot of times, insureds, if they're a homeowner or an owner of a company, they're not really sure why you're involved. They just want their home fixed. They want their their worker compensated and back to work. But it gives you a chance to be involved and to recognize the issues and really explain why you need to investigate this accident or this loss. Essentially it's going to be a walkthrough of your third-party lawsuit. You have your evidence, you have your experts. They're going to let you know if what other evidence they may need. They may need to take, I need to take all of this gas line coming from this fitting. I may need to take this dryer, even though it may not be part of the loss per se, but if a gas line leading to the dryer failed, well, we need to save this as well in order to eliminate if other causes. So gives you that chance. You can lock witnesses into positions, and testimony. You can, if they change their story, throughout, you can kind of get to know the testimony that's out there, and if they change it in the future, then you're at least going to know that. If you don't, if you don't investigate or interview them until weeks or months after, they may not remember, or they may remember incorrectly. Also, the final one, notice to parties and government entities. Most of you probably know that the governmental entities operate on their own notice requirements. A lot of times, it's a much shorter window to give them notice of a claim. And so, if you have one involved, just take care of that. That you get them notified with your claim information and whatever else may need to be required in a timely fashion. So how do you do this? You take statements, recordings, you get experts involved to take photographs and preserve the evidence. You may have investigators, interviewing witnesses. You really just need to document the scene. You need to document what happened, and then you can kind of try to figure out why it happened. But engaging an expert right away is a lot of times important, or at least an investigator, to kind of pinpoint your cause and origin, to make sure that all the evidence is being kept track of in a in a timely fashion, so that nothing gets lost. And then you can look at the case. You can summarize it for your colleagues to take a look at, and even maybe engage subrogation counsel to assist with either the investigation itself, or if your case is a good one, to either take the trial or just make demands in how to proceed. So, as I said before, hiring an expert is important. So how do you hire? How do you select and hire an expert? And really, it comes down to, a lot of times, who you are comfortable with. You need to work with the expert and provide some direction, and also take some advice from him on what needs to be done. A lot of times, you should try to hire these experts, right away, especially a cause and origin. If it's a bigger loss and, there may be some mechanical or electrical issues, you may want to get an engineer involved right away in order for them to make sure you preserve enough evidence. Origin versus cause, you have, a lot of times they're called cause and origin experts, because they're looking at, where did this fire originate? Where did the loss originate? And then what caused it? Well, it's the washing machine. The insured noticed that water was running out of the laundry room. We see a crack in the drum of the washing machine unit. We can take this and secure it for further inspection by an engineer. If you have some sort of a workplace accident, you may need something like a human factors, a biomechanical engineer, to kind of take a look at, well, how did this person interact with this part, or how did this person interact with this product. And I'm sure all of you have seen expert databases and referral companies, and while those are fine, you still need to be comfortable with your expert. You really need to interview your expert just like you were to interview another, an employee or even an attorney. Have they handled these losses before? Do they have an understanding of the product involved? So if you're comfortable with them, then you can kind of look and see, the budget and how cost effective they're going to be. A lot of bigger companies, Rimke, Stone, just to name a few, they're nice because they have a national presence. And you can give one call and find somebody, but you really still need to be comfortable with that person and comfortable with interacting and comfortable with trusting that person. I've had a couple of cases where it's nice to find somebody that is an expert in the field that they're investigating. There was a large valve that caused a workers' compensation loss up in Idaho, and this valve came from a hydraulic dam. And we were able to find an expert out of Seattle that used to design and operate these dams. And so he had a knowledge, and as soon as he was able to come in, he asked the right questions. He knew which questions to ask, and it put the insured at ease, and it also gave us the best chance, in the future of recovery. Sometimes it's in a larger loss. It may be more cost-effective to even fly in an expert from somewhere, because in the long run, they're going to save you money by knowing what to inspect, who to put on notice, and what are the previous, losses in this instance. And so sometimes it can be just as cost-effective to fly in an expert as to grab somebody that is down the road. So just some tips for handling experts. You really sometimes need to help the expert understand subrogation. Just because you're an insurance company doesn't mean that you're defending the case. And that can kind of be the default setting for a lot of experts. They hear, insurance company, they think, well, we're defending the case. And while I like to say that, all experts should be impartial in their views, that initial bias can kind of help or hurt. And you need to state that, we're trying to prove this case, we're not trying to defend it. And it kind of cuts both ways in that, if your expert really understands the case, he's going to know some of the defenses that they're going to try to, attempt to bring. But, you really need to explain that, what you're doing and, and how you would like to go about doing it. With regards to reports, at the start, I always say get a verbal report. Save the written report for litigation. It's, a written report, the expert's file is discoverable, and so, a lot of times if you can just get a verbal report, you can oftentimes save money, especially if it's a case that, where there isn't a good subrogation potential, but you need to have some sort of an inspection just to find that out. Well, just get a verbal report from the expert, and you can kind of walk through what went right, what went wrong, how can you proceed. Just be aware of chain of custody issues. I know a lot of insurance companies have their own, evidence storage, but a lot of times it's staying with the expert, and most experts have some sort of a chain of custody form or a chain of custody process, so you can verify that this part has remained, within somebody's control at all times. And just a final, on a damage experts, we're seeing this a little bit more now in more complex cases. Daubert is a federal case where and a lot of states have adopted the Daubert ruling in that not only, must your expert be qualified, but he must also base his opinion on some sort of, I want to say, scientific background. He needs to have some sort of basis for his opinion in order to be, qualified. And we've seen that kind of being thrown around too now. If you get a separate person on damages, and so a lot of times, he's going to have to potentially not only, state what the damages are, but he's going to have to explain, how he came about on this this valuation of this, piece of heavy machinery. What are other, pieces of heavy machinery going for? Why he came to this valuation? So just kind of be aware that, sometimes, if he's going to be an expert and you're going to call him an expert, he may need to meet some heightened requirements. So at this point, I think what we're going to do is we are going to do a little bit of trivia in this case. And the first person to either email Jamie Breen in our office or to type it in the chat or submit this to us will win one of our books. The 50 state compilations. My favorite is the workers' compensation subrogation book, but the automobile or the fundamentals of insurance defense or ERISA are all extremely popular as well. So the trivia question is going to be, what is the total annual dollar value of property damage caused by defective products in the United States? And so the first person to get that to Jamie will win one of our books, and we'll announce the winner of that at the end before I take some questions. I'd like to talk just a little bit about any large loss property investigation. We've kind of hit these before, and so I'll just kind of go through this and that. One of the main things you want to do is just to make sure that everybody is involved. Put everybody on notice. Get your cause and origin person involved. Get an engineer involved if needed. If you know what the cause was, a surveyor. And the goals of their defense are always that they're going to try to prove that there's an alternate cause and that you spoliated the evidence somehow. And so you just kind of want to avoid those two instances. And spoliation kind of gets thrown around a lot these days, but the definition is the intentional destruction, mutilation, alteration, or concealment of evidence. And in truth, that intentional part kind of gets left out, and it undermines the truth-seeking function. So it gets thrown around a lot, but in most instances, it's either not applicable or there are, the effects of it, are not as perceived. So, if you do everything, if you're diligent in providing notice and protecting the scene, establishing your chain of custody and preserving the evidence, a lot of times you're going to defeat any kind of a spoliation claim. The two sanctions would be, either adverse inference that, well, they destroyed this part because it would have damaged their case. It's only a presumption. It's it's in a jury instruction. It's not a complete, dismissal, which some states do. If you, they could strike the introduction of the evidence, if they don't dismiss the case outright. And a lot of times, if the court strikes your introduction of evidence at trial, then that can't be taken into effect, and so, your case is going to be lost anyway. But if you take the necessary steps, a lot of times, defense adjusters will throw that around without a whole lot of basis. Since we're getting a little late on time, I'm just gonna kind of talk about handling insurers just a little bit. You can oftentimes, you need to explain the concept of subrogation. You can explain the process, explain what you have to do and why you have to do it. The issue is always, the insureds want the repair to start, immediately. And if you, can explain why you need to take the time to preserve, your case, a lot of times, that'll go far with regards to, them being understanding that you need to take a week and, get everybody on notice and get people involved to properly document the lost site. So, they always want their repairs to start, immediately, but a lot of times you need to take a step back, at least for, a day or so, just to make sure that everybody is on board and that you're doing enough to protect the scene. I'll talk a little bit about some of the common product liability failures that we see, and I'm sure you guys are on the front lines of these claims, and so you see these a whole lot more. But the classic is the water supply line. Either you have the braided hose or the plastic coupling nut will fail. I think after this, and after handling product liability, losses, I think everyone needs to go home and check their water supply lines, because the braided hose is made most times from stainless steel, and most people think, well, stainless steel doesn't rust. Well, that's not entirely true. When it comes into contact with a chloride, the chloride can break down the metal and cause it to fail. And most supply lines are made of a two-part system. They have an inner hose, which is made of a plastic, and then they have the braided supply line, or the line, which is supposed to, essentially protect that inner hose. Well, as manufacturers have gone on, they've made that inner hose out of a cheaper and cheaper plastic, and so it cannot handle the home's water pressure in and of itself. The braided part really does that. So when you lose the braided part of the supply line, a lot of times you're going to get a failure of the inner hose right there. Manufacturers used to make it a three-part system. So that inner hose carrying the water was surrounded by another hose, which was surrounded by the braided line. So if you had a failure of the braided line, you still had two hoses inside that would hopefully, protect it until the insured saw it and, was able to fix it. And if you had a breakdown of the inner hose, you still had two levels of security. And I know that some manufacturers now are moving back, not to the three-hose system, but they're making that inner line a little beefier to be able to handle these, because, as you know, these supply lines are under cabinets. They're in behind toilets. People are not looking at these supply lines, even though, the common defense is that, well, it's a replacement part that you're supposed to inspect. Well, I've never inspected the hose underneath my kitchen sink, but maybe you should. But a common homeowner, probably will never think about that until it breaks. The plastic coupling nuts, I like the water supply lines with metal nuts on both ends. The plastic coupling nuts, plastic is is a loss point in that it's not. Some plastics can withhold stress over time. Others are not as is not as capable. And so when you have a plastic coupling nut that is screwed onto a toilet, a lot of times if it's leaking, the insured will simply give that another twist or take a wrench, and even though you're really not supposed to, take a wrench and tighten it down some more. Well, that just puts additional stress on this plastic, and over time, that plastic is going to fail. In the past, they've said that, well, this nut has to be hand tight plus a quarter turn. Well, they've now backed off of that even and said just hand tight. And sometimes they warn about that, sometimes they don't. And so if it's on there too tight, it's not going to fail right away, but it's going to fail over time. Washing machines and clothes dryers. Clothes dryers have with the fires, the typical, you need to determine what was the cause of it. Was the lint trap cleaned out regularly? Was if that was, then what's the other? Is it is the drum on a bearing that failed? Is it the gas coming into? If it's a gas dryer, washing machines, there's a load of different ways that inlets can fail, water inlets. The drums can break. The base of it could break with just the jostling of the machine. So there are different ways that can fail as well. Fireplaces, there are a couple of different ones, and we've been seeing a lot of pellet stoves lately that have started on fire, just due to the inherent, use of the product. You have, pellets that are being fed by an auger into a burn box, and a lot of times they're not meant to be the primary heating source of the home. And so a lot of times they're overused, or if the auger is run by, electricity. So if that auger or the electricity goes out and you don't have a battery backup, all of a sudden you have the chance where the fire can spread, back up into this hopper full of pellets. Fireplace inserts, a lot of times you'll see that the clearances weren't taken care of too. A lot of times, you need at least, an inch or so of clearance. Codes kind of vary on that, but a lot of times you'll see inserts being put, if it's not sized correctly, it can, if it's in touch with a wood stud or a piece of insulation, it may not start fire right away, but it may, over time, the heat's going to build up to the point where a fire will start. In plastic failures, I kind of touched on that. Why they fail. The threaded coupling nuts. A lot of times the stresses involved. It really needs to be the correct type of plastic. It needs to be designed correctly. A lot of times it's the threads are too sharp, and so that kind of adds increased stress. And the plastic is going to fail over time. It's not going to be an immediate failure. Foreign manufacturers, I know this is another kind of hot button topic, just because with the difficulties, the cost, and the time. You have legal issues to avoid. A lot of times a foreign manufacturer isn't going to be, subject to the jurisdiction of the United States court if it's purely in a foreign country and it has never made any advances to either market or sell its product in the United States. A lot of these supply lines that you see are coming from China, Taiwan, other electrical cords or electrical parts are oftentimes manufactured overseas and then brought in. Some states allow you to pursue the supplier or the distributor, which is great because then you at least have somebody in the United States that you can hold responsible. And a lot of times, if it's a big enough loss or if it's a more sophisticated part or manufacturer, the supplier will put pressure on the manufacturer to be involved. If it's just a water supply line, you may not get that because a lot of companies are making these supply lines, and it's easy to get these from various entities. Here at Matthiesen, Wickert, and Lehrer, we're trying now to kind of pursue these matters in either Taiwan or China directly. It's an area that we know that our clients are facing issues in, and we're trying to come up with a way to potentially pursue these cases directly in their home countries rather than going through the cost and the expense of the foreign service. So we're excited about that, and I think we're just trying to figure out a way to do that would benefit everyone, as these tort reforms and other laws are kind of shifting the tide back against against really the U.S. consumer, in that they really don't know where their products are coming from, but a lot of times in order to save costs, they're being manufactured somewhere overseas. So watch out, especially for any of the statute of limitations trap that I talked about earlier, because if all of a sudden you have a foreign manufacturer, you need to get them involved, and it's not always easy to find out their name, their address for service, who is involved. So if you need to file suit in order to learn that information, at least you have some time on the back end then that you can bring these people into the case if needed, and you're able to, you have the time in order to do that. If you're running up against the statute of limitations, you may get burned in the end. So, we always like to see these get to legal counsel early so that there's enough time to fully investigate and get everybody involved that's needed. So just finally, some subrogation tips. You just want to quarterback the recovery from the start. Get involved. Be the person that is handling the investigation. That you know where the experts are getting their information from. What they're stating as far as causes of origin and the cause of loss. And subrogation is an investment, but it's also one that you want to do it in a cost-effective manner, so you're not outspending your recoveries. So take the investigation seriously, preserve the evidence, identify any qualified expert that you need to assist. Find out who else owns this loss. Is there a landlord or a tenant, or is there a contract, an indemnification contract? Who else can be brought in to own this loss rather than just simply the classic, you pay out and you're going after this third party? Is there somebody else that should be paying out on this loss? And if so, then your investigation may be fruitful. And as always, we're stating you always need to think subrogation. So we just have a couple of minutes for questions. I have a few here to answer. But I guess first, our winner of our book is Marian Dimitrowski from Pure Insurance. And Marian, Jamie will be contacting you after the webinar to find out what book you'd like and to get all of the shipping address. And the answer to the question was that $500 billion is the total annual dollar value of property damage. And so a lot of people were on the low side, but it really is it's something that everyone deals with and that really causes a lot of harm. one of my other questions that I would like to ask, what the number of Americans injured annually by defective products, and that's anywhere from 30 to 35 million. So it really is a big problem that we'd like to get a handle on, and especially with regards to foreign manufacturers, we were trying to find a way to to bring them in and make them responsible. As far as questions go, I just have a couple minutes here. I got a question on the cost of foreign service of process, and a lot of times, if it's one of the member countries of the Hague Convention, China is one of them, England, some of the other European countries, you need to hire a foreign process server to translate the documents into the native country language, and then to serve them via the Hague processes. If it's just as simple as that, it'll cost you anywhere from $1,000 to $2,000, depending on how many documents you need to translate, how many pages. If they're not a member of the Hague Convention, Taiwan is not, because China will not let them be. It's a more onerous process, and you not only need to translate the pages, but then you need to go through diplomatic channels to serve these. In a recent case, that came out to be right around $4,000 to $4,500. So it can be costly to serve a foreign manufacturer, especially when there's no guarantee that they're going to be liable in a U.S. court of law. And that kind of dovetails into another question, when is it cost effective to file suit in a product liability case? Well, it may always be cost effective to file the suits, but it may not be cost effective to take to trial, just because you're dealing with experts where you have they need to investigate, they need to inspect, they need to write a report. They're going to need to review the other experts' reports. They're going to need to be deposed, and they're going to need to provide trial testimony. So a lot of times, if that can cost anywhere from $10,000 to $15,000 on the low side, just depending on how many experts you have involved. So you really need to take care early on. If it's a lower value case, sometimes you can do things. You can have the expert, if you're not going to take it to litigation, you can have the expert write a strong report and present that to the other side, in the hopes of getting some sort of settlement right off the bat, rather than being drawn out. That might be a good investment. It may be cost effective to just get a verbal report and pursue it as far as you can, and then not take it to trial or file a suit to try to get a settlement and not take it to trial. So there are a lot of different areas and ways you can go about trying to do this in a cost-effective manner, because I think everyone needs to just be aware that it's if you're making a recovery, and you just need to outstrip your costs in order to be effective for everybody. So I know there are some other questions. I will respond to those as soon as I can here after the webinar is over. But I really like to thank you for your time this morning. If there are any other questions that you think of next week or in a couple of weeks, my contact information is there. You can always give me a call or shoot me an email, and I'll be happy to give you whatever insight I have. So once again, have a great rest of the day, and thank you for attending our webinar.